Thank you. Good morning, everyone. Can I request you to be please seated? We are starting with the first session for today. Can I request the dignitaries to come on the dais, please? Justice Pitle, Mr. Jaideep Gupta, Mr. Thiru.
One more, please.
Shift the chair. There's an extra chair here, Stephen. You can come this side. And so can Dr. Hasnain.
Do you pronounce it as Hasnain? Yes, because we have the same community we have here. Two gentlemen, very eminent gentlemen called Hasnain.
Yes.
Both scientists.
So I guess we start. Good morning, everyone. This is working session 3, sovereign debt crisis and the rule of law. I'm very happy to chair this session because we have a very eminent panel today. We have Mr. Jaideep Gupta, Senior Counsel, Vice President of the Bar Association of India. Mr. Stephen Thiru, who is President of the Commonwealth Lawyers Association. Dr. Mohammed Hasnain, Member, Egypt Bar and Vice President, PALU. Mr. Hiran MC D. Alvis, Chairman, Board of Governors, Sri Lanka National Arbitration Center, and Dr. Manoj Panda. He is a full-time member of the 7th Finance Commission. I, in fact, had shot off an email in our group the other day to give an outline of the possible structure of the discussion we have to have today in this session. The responses from the members gave me an idea that each of the members of this panel have their own unique perspective about the topic of discussion, and therefore I thought it appropriate that I'll just give some opening remarks and then open the house to them to give their own unique perspectives so that we have a meaningful discussion in the next about an hour. And if we have time, we can have a question answer session towards the end. As regards my opening remarks, I was just going through this topic, and in fact, my thoughts were triggered yesterday by what Prashant Kumar, the President of the Bar Association of India, mentioned about the rule of law, effect on rule of law, in the backdrop of financial restructuring, financial architecture, and governance, and what sovereign debt crisis can perhaps lead to. As far back as in 1776, Adam Smith had talked about this. So the humankind has been thinking about this issue for quite a long time. He had said that we have to have a fair and open bankruptcy procedure for an insolvent state. This is a topic engaging our attention for a number of years. And what better platform can we have than the United Nations to discuss this issue. If you go about a decade back, 2014, you'll see that the United Nations passed a resolution which was supported by a majority of countries, which concerned about a restructuring of sovereign debts and the mechanism a multilateral mechanism that can be devised. Although it was supported by 121 countries, but predictably, the developed world, the global north, the creditor nations either voted against it or abstained. And in any case, although it was passed by majority, it was blocked, and eventually, a year later in 2015, there was a resolution passed by the United Nations on the insistence of G77 countries, which was a milder version and which just said that we should have general principles of restructuring of debt. So much for the effort being made at the level of the United Nations. We've had a series of conferences in the context of financing for development, the latest of which took place in Spain recently, in Sevilla. And if you see the journey of that conference from 2002 in Monterrey in Mexico, 2008 in Doha, 2015 Addis Ababa, and recently in June and July in Sevilla, Spain, we feel that there is a gradual move towards taking some concrete steps. But frankly, there's not much teeth given to the procedure that is to be devised. So I was wondering in this discussion if the panelists could focus on the need for a multilateral independent dispute resolution mechanism, a kind of a mechanism which gives a neutral platform for such debt crisis to be resolved, where all the stakeholders have their say, and the fear of the developing countries, the debtors, that they are being exploited is taken care of. Now, if it is to be established, I take a parallel from a domestic legislation. We have what is called the MSME Act. It concerns the micro, small and medium enterprises. Statutorily, there is a facilitation council under the provisions of that act for disputes between suppliers and buyers to be resolved, where once a dispute is referred to the facilitation council, statutorily there has to be mediation. And if it fails, then it goes to arbitration under the aegis of the facilitation council. So if we can think under the United Nations of such a facilitation body or a council for resolving such crisis, will it be more advisable to do so? And then the nitty-gritty of it, that who can trigger it? Will it be the borrower, or will it be the creditor, or both can trigger it? And upon triggering it, can we have some sort of a moratorium so that the repayments that are to be made are at least stayed for the time being? So these are issues we need to think about, because we do need an independent multilateral dispute resolution mechanism, in the absence of which the exploitation of the have-nots is likely to continue. We also talk about colonialism, the social debt that the colonizers owe to the colonized people. Their resources were exploited over the years. Whether that is a debt that needs to be thought about, taken care of in this kind of a mechanism that can be developed. Do we need transparency? Do we need a debt registry under the United Nations, where debts get registered, and only those debts that are registered with transparency in all the data and details could then be taken as the basis for enforcement in national courts? And do we need a United Nations Convention for agreement between the nation states, member states, for domestic legislations, for taking care of a responsible ecosystem for lending as well as borrowing, so that there is lack of, the issue of indiscriminate borrowing is taken care of. There is complete transparency. Nothing is hidden from the people, because they say that while creditors are paid, the governments start defaulting on their own people. There is a lot of human cost that is paid by the populations of such debtor nations. You have increase in unemployment when the crisis really deepens. You have cutting in public spending. You have consequential recession. You may have uncontrolled inflation. So it's the people who ultimately matter. So human rights, in some cases even ecological issues, or even biodiversity may be adversely affected unless the debt crisis is taken care of. So all these issues may arise. I believe that Mr. Stephen Thiru is to concentrate on what is called predatory lending, and whether that issue can be taken up with the United Nations Convention Against Corruption, and whether this is a form of corruption that affects a large proportion of mankind, and therefore such issues need to be flagged, considered. I believe Dr. Panda would be giving the Indian perspective on the matter, and since, as I mentioned earlier, each of the panelists has his own unique perspective to the matter, I'm looking forward to the discussion. And with these opening remarks, I request Mr. Jaideep Gupta to place his views before us.
Good morning, everybody. Justice Pitley, in the audience, Justice Mai, our former Chief Justice of the Calcutta High Court, Justice Prakash Srivastav, who is now in charge of the Environmental Tribunal, the Apex Environmental Tribunal in India, and my co-panelist, and everybody who has braved an early Sunday morning to join us for this session. I'll just take 5 minutes to indicate one aspect of this today's session. We know that the basic principle of rule of law is that law should govern and not anything other than law. But we take it a step further and we say that there are certain very primary principles which must be there for there to be rule of law. For instance, equality and other aspects. Now, rule of law is not rules of law. There are a million rules of law, but rule of law is not that. It is those principles, 3 or 4 of them, which are universally accepted. And every nation on earth at least tries to provide for it in their jurisprudential system. Now, perhaps the most important part of this discussion ought to be what are the corrective mechanisms available to ensure that the rule of law provisions which are embedded in every jurisprudential system are not given a go-by, or to bring the system back to where the rule of law is being followed. That's a very important principle which we have to look at nowadays. Now, sovereign debt was discussed in brief by our president, Mr. Prashant Kumar, yesterday. He was talking about sovereign debt and principles which are to be applied to it on a multilateral basis. That is, he was talking about how to ensure that sovereign debt is not dealt with in any unfair manner by the nations which have been responsible for lending. Today's session, at least on paper, subject to what my co-panelists would like to make of it, is more about how to handle it within a particular jurisdiction. When we talk about a multilateral problem, then of course we are looking for multilateral institutions, as Justice Petele just pointed out. Alternatively, there is another possibility, and that is, as more and more nations follow these principles of rule of law, then the approach of every nation is on the same page. And so therefore, that is another method by which it can be brought about. As far as our constitution is concerned, and I'll just end with this thought, we have a constitution which provides for some of the principles of rule of law in a chapter on fundamental rights. Like, for instance, the principle of equality. This is enforced by our courts and enforced rigidly. Now, sovereign debt and how to deal with it are matters of policy. By and large, it is well settled in our jurisprudence that policy matters are not to be gone into by courts. Courts do not review matters of policy. What has to be done is to see that the executive and the legislature are, whether they are following the principles of rule of law or not, but the court cannot intervene. However, we have another device in our constitution, a very interesting device, and that is a chapter called the Directive Principles of State Policy. And the Directive Principles of State Policy, while not enforceable in a court of law, are fundamental to the governance of this country. And those directive principles, please take a look at it at some stage, contain, particularly in Articles 38 and 39, several of the principles that we think are part of rule of law. For instance, the need to be fair in the equitable distribution of the resources of the country. Now, the directive principles are guidelines for the government and those who are governing. It has also been utilized by our courts to give meaning to fundamental rights and other provisions of the Constitution. So even though the Constitution itself provides that it is not enforceable in a court of law, the courts have attempted to enforce it to some extent possible by using it to interpret and give content to other provisions of the Constitution. Now, with those words, I would like to hand it over to the panelists of the day. Thank you very much.
Thank you, Mr. Gupta, especially for the Indian Constitution perspective that you sought to give. Now I request Mr. Hiran MC De Alvis, the Chairman of the Board of Governors, Sri Lanka National Arbitration Centre, to give his views.
Good morning, ladies and gentlemen. Apologies for the Sunday morning, and namaskar to my Indian friends. So, I think a brilliant introduction by Justice Manish gave some thought-provoking ideas there. Also want to make reference to what the Indian President, the Bar Association, Mr. Prashant Kumar said yesterday, and he gave some very interesting ideas as well. So thank you for inviting me and to share my humble thoughts with you. Now, I'm actually a practicing lawyer and arbitrator, but I'm here as Chairman of the Board of Governors, Sri Lanka National Arbitration Centre. That is an honorary post. So my views here would not be really the views of the organization per se. I will be, for a thought-provoking discussion, giving a slightly contrarian view, because with such an august assembly here, to do justice to this topic in 15 minutes when you need a doctoral thesis is not fair by me. So any controversial thoughts, please bear with me. So, as you know, we are all members of the legal fraternity. So I strongly subscribe to the view that we must follow the rule of law. So I am seeking to look at a solution within the rule of law. So what is known as sovereign debt crisis, there are certain issues. And a solution has to be found in this day and age. We are talking about technological innovations, other dramatic developments in various fields. Why cannot the legal community put their collective thoughts and brilliance, if I say, and come up with a solution? Very salutary thought was given by Justice Manish in the morning. In fact, I wanted to build on it since I am a member of the Board of Governors here. An internationally recognized dispute resolution system, which might be an amalgam between private and public law, has to be found. I think this is an innovative idea which we can expand upon. Of course, it will be good for lawyers as well, but it will be good for the countries as well. I think because there are situations where there are individual cases filed in certain countries against individual nations who are finding it difficult to come up with a solution to the debt crisis whilst meeting challenges in local courts by various lenders, some with good intentions, some with various other intentions. So it is a serious problem for the people. So getting back now, broadly speaking, if there is a sovereign debt crisis caused by what is called a force majeure situation. Now all of you know what is force majeure. Here I am referring to an uncontrollable force. So let's call it the dark force. Force majeure may be act of God, this might be a slightly different force. For example, during the COVID crisis, there were resultant economic lockdowns. Several nations were crippled. Trade was stopped. What do the countries do? Directives were issued by the World Health Organization. Comply. No complaint. This led to economies collapsing. And we know even in our region this happened. The resulting economic disruption forced these countries to confront the debt crisis. They were prevented from servicing their debts. Inflow remittances from migrants, export industries stopped, led to a balance of payments crisis. And the people in this country were left helpless. So if there is a sovereign debt crisis caused by these external forces, how do you address that? Now there are self-inflicted sovereign debt crisis, corruption, predatory lending, etc., etc. That is very topical, but that's a topic for another day. So my concern is there has to be a solution to what the debt crisis that has been caused by this major, force majeure or dark majeure situation. Now, solutions should come to this from the multilateral agencies itself. For example, whilst appreciating the help of the International Monetary Fund, World Bank, etc., which have done great things after Bretton Woods, if you look at their preamble and their intentions, can we come up with the thought-provoking idea how to meet this situation? Should we have an economic Marshall Plan? After the Second World War, as you all know, this help assisted all these countries, very much developed countries now, to come out of the horrors of the war. Isn't this a similar crisis? We cannot have sovereign nations paying 60% of their income just to service debt in the present crisis. This is leading to a vicious cycle. And the people are trapped in this vicious cycle, especially the people at the bottom tier of the social ladder. So I am not advocating a breach of these agreements, only a solution within the agreements. That means a solution within the rule of law. I think this will also lead to a spurt of economic growth. So, since we have been talking about this point at various forums, I would like to suggest, very humbly, look at this innovatively, maybe with 3 steps. A debt reformulation strategy with specific timelines and specific interest rates to cover this force majeure or dark majeure period. Secondly, protection against currency depreciations, which exacerbates and increases the debt these countries have to pay. Also, a freeze of interest for such period, of course, but is just an equitable. I am not advocating a reduction of capital component borrowings. That is a matter for each sovereign nation to negotiate on its behalf. As you know, my country, Sri Lanka, one of the first countries in South Asia to liberalize the economy in 1977. Very few know. Unfortunately, about few years ago had to face a sovereign debt crisis caused by various situations, some internal and exacerbated by the COVID lockdowns and the defaults. So, however, with a little help from friends and including our neighboring country, which we are very grateful, we had a dramatic stabilization, I must say, irrespective of politics or whoever. From 70% inflation, it dropped down to 7% within 2 years. Stringent austerity measures. Currency was stabilized. Growth is now up to 4%. But now with debt repayments, that growth of 4% is not enough. Do we want to get caught in a vicious cycle again? So these statistics I am mentioning with reference to the central bank reports. Now, GATT, WTO, World Bank, IMF, as you all know, means a set of rules. So as I said, can't they come up with a mechanism to modify these set of rules, not to break them, modify the set of rules. I think that was the ideas of the opening remarks. And the principles of state policy was referred to by my learned predecessor. In fact, even in our constitution, it is not enforceable, but it is there. So if the IMF, World Bank and all these agencies enforce fiscal discipline and austerity, my discussion is, if these financial difficulties were caused by matters beyond the sovereign control, as I said earlier, should there not be a mechanism, and in fact there should be a mechanism within the system to provide technical assistance to promote growth. This is a serious lacuna. This has to be addressed now. I am reading through this topic, grateful to some of the thoughts being shared by the new World Bank President, Mr. Ajay Banga, even the IMF head, Ms. Georgieva, who have been very concerned about this situation, I must say. However, they themselves realize the situation. I think Mr. Ajay Banga, in a speech with Reuters, in an interview with Reuters, said, world economies are now facing their weakest long-term growth in 25 years. World Bank has to look at reforms to create job creation, which is an innovative idea. Noting 1.2 billion young people are expected to enter the workforce in developing countries over the next decade. But only 420 million jobs were on the horizon. So this is not an economic issue only for the sovereign debt crisis, it's a global issue. Now, is higher taxes and higher debt payments the only way out? In my opinion, millions of people within the Asian region per se can be lifted out of poverty if there is a slightly innovative approach. There is with this a possibility for dramatic economic growth as well, if such restructuring and recalibration is done properly and fast. I would say carpe diem, seize the moment. Now I am advocating this slightly contrarian view. However, there is also duty cast on these countries to implement structural reforms, improve on governance. That is vital. Transparent auditing, I think some of my learned colleagues will refer to that. Look at prudent borrowing. Those things must be looked at. Now, if sovereign debtor nations or those in power or external borrowings or the dark force situations cause the economic crisis, what do the people of this sovereign crisis do? They would be helpless. They are helpless. So, those in the financial, legal, banking sectors, whilst adhering to the rule of law and their structural lending policies, must come up with an innovative solution. And within this audience itself, speaking casually, there were a lot of ideas exchanged. So if there is so much of strategic thinking here, within the region itself, I think we should come up and push for these solutions within these multinational agencies. Sri Lanka's former Foreign Minister, Lakshman Kadirgama, in a book some time ago on a different topic, Seven Sisters of South Asia, he was referring to the South Asian countries, says there are problems, but they are not intractable. He called upon the professionals in all these countries to get together and work out solutions. That has to be done, and we are grateful for seminars such as this, for bringing people together and to have an exchange of ideas. But talk is not enough, something has to be done. And we are proud of India's success today, I must say. I was in Bangalore in 1992 as a young law student taking part in one of your moot competitions. I think India was just coming out of a financial crisis. I think the prudent handling of that situation is an eye-opener for all our countries. These prudent policies has resulted in dramatic growth and a reduction of poverty. So it is actually surreal that after so long, I am at this podium addressing in India on a slightly different, on a topic like this. So coming to the legal system. So whilst there is a plethora of legal institutions, rules, experts, let's look at some, or let me broach some thoughts. In our country, Sri Lanka, within the law itself, this is for example I'm saying, we have certain elements of the Roman Dutch law, part of our contractual heritage. It is, one principle is the principle of unjust enrichment, which is recognized in our law. So the rigors of the law sometimes are tempered by this thing. Now the same principle I would like to advocate. Can there be unjust enrichment on a debt servicing period for a situation caused by this dark force? Should not these legal principles be looked at? If you look at the field of international commercial arbitrations, as you all know, it arose after the horrors of the First World War. Establishment of the International Chamber of Commerce, the New York Convention. So this became the Magna Carta of international trade, dispute resolution. This also arose out of a war. We are now facing an economic war. Not only the Asian regions, other regions as well. So what I would say is, honor these international treaties, honor the rules, let the rules itself come up with a mechanism to recalibrate this sovereign debt to promote economic growth, prosperity to the region, and especially for the people of the region. From statistics, about 15% of our country slid down to poverty for no fault of their own. They have to be protected. So whilst I said we had these commendable fiscal austerity measures, belt tightening as they call, no imports, we couldn't import cars for 4 years. There are other repercussions. Young professionals leave the country. people who had minimum savings for their retirement, have them wiped out. You have to look after them. So, international dispute resolution mechanism would one possibility of looking at this in a holistic manner. Now again I emphasize the point that we must follow the rule of law. If not, what happens with sovereign debt crisis? Even private contracts get breached. For example, contracts, let's say a construction contract funded by a multilateral agency would be stopped due to the sovereign debt crisis. There is a breach of a contract. People lose jobs. Governments itself might move to arbitrary governance. They might look at suppression. Just before I came here, since I was speaking on this topic, there was a protest march going in bold red letters. So I opened my car window and got one to my hand as well. Immediately called for exit from the IMF, kicking out of all politicians who are subscribing to the IMF. So, whilst we may not subscribe to that view, we must give ear to that view, otherwise there will be a social crisis. That will also lead to a breakdown of the rule of law. That is why it is imperative to come up with a solution. So, again I say with these innovative approaches, before I conclude, we must strengthen the anti-corruption laws domestically, improve transparency on these borrowings and what the agreements that have been signed with multilateral agencies, possibly build up an emergency fund for these countries within the budgetary allocations itself for short-term relief, develop a sovereign debt fund within these multilateral agencies, what is with a special drawing rights as an immediate short-term measure to protect the vulnerable and marginalized. I think all this can be done whilst following the rules and the rules of law. Thank you very much.
Thank you, Mr. Hiran de Alvis, for your wide-ranging views on what you said was innovative in a way. Now I request Dr. Manoj Panda, member of the 16th Finance Commission, to share his views.
Chair, Justice Pitle, Mr. Gupta, Mr. Thiru, Dr. Hassanen, Mr. D. Alvis, co-panelists of this session, and the distinguished audience. I would like to start by thanking the Bar Association for inviting me to speak in this session, even though I am not from this discipline. I thought I would like to speak, given the topic, I would like to speak on a few minutes at least on the sovereign debt crisis India faced. And that was quite some time back, but everybody knows about it because that was the time India's economic reforms started. That happened in 1991. There were also, foreign exchange crisis, debt crisis earlier also, but they were not of that proportion to be called that they were crises. India did take loan earlier also, but after 1991, that is taken as a kind of success story for India, that they were able to meet the crisis and they were able to turn the table around so that it doesn't occur, at least not within the normal situation. The immediate trigger of 1991 crisis was again external, which Mr. De Alvis was referring to, though it was external of that time. The Gulf War that happened in 89-90, the global oil price rise, export fall, world economic fall, and so on. And of course, another political development that took place that time was disintegration of the USSR. Now, all these factors contributed, they were triggering factors. But the debt crisis in India, it was actually building up prior to that. The foreign trade deficits and fiscal deficit both were getting widened, and debt accumulation went beyond the safe limit. Then IMF, of course, there was an election, and after the new government was formed in the mid-1991, India approached the IMF for a loan. The loan, as we all know, IMF loans don't come without conditionalities. The conditionalities were there. Not only to correct the fiscal deficit and the trade deficits, but also that time the conditions also, at least broadly, it was to open up the economy to private sector. And this last point, that possibly was getting realized even in the Indian policy making circles. So they were getting ready towards that, how to open it up without the IMF loan. Maybe it would have taken longer, but it would have happened anyway. May not be exactly in that form. Now, in any such loan, as the chairman was telling, when there are adverse effects on the conditions, on the life of the people, actually, in a sense, governments are defaulting their own people. And that happened in India also, but possibly it did not go to an extent where people will come to the streets. Now, why did that happen? And it is here that possibly some of the success stories remain. Prior to that, India was a food deficit country, but by 1975, late 70s, India became a surplus food producer. And then it was intervening in the procurement and distribution of food grains market to a large extent. And slowly that expanded actually. By the time we took the IMF loan, it was quite extensive. It started during the World War by the Britishers to meet the food requirement of the urban area only. But slowly it expanded. So that possibly is one thing which helped the people at least to meet their food needs. And fortunately, a few years later, the Supreme Court interpreted in 2001 the right to food as an inherent part of fundamental right to life. So slowly, the expansion of the procurement and distribution mechanisms can be explained that way, and that was that was built of protection mechanism, at least for life. Later on, after meeting the crisis and long after that, in 2013, the Union government also introduced the National Food Security Act, targeting about 65% of the bottom population. So now possibly situation, at least on that front, is much better. Before that, the government also had introduced something to protect livelihood, not so much, but partially, about 100 days of employment to be guaranteed to any family in rural area who are willing to do manual work. Now this program called National Rural Employment Guarantee Program, it is named after Mahatma Gandhi, that also helped to some extent, and particularly that was evident in both the acts, the National Food Security Act and the NREGA Act. Both the effect of that were actually evident during the COVID crisis, which was again, an external crisis. It was not a debt problem that time, but even then it was a question of life and livelihood. I will not say that the government met it perfectly or there were no improvements possible, but again, broadly speaking, possibly India did a good job even during the COVID time. Now, coming to some structural aspects, how did India avoid the crisis after 1991? One basic instrument for getting the economy on track and improving its living conditions is obviously economic growth. And except for initial few years after 1991, the economy came back to about 5.5%, 6% and slowly to 7.5% also. Again, it has come back to about 6.5% now on an average. That's the real growth. And with that, possibly the economic base of the country has expanded sufficiently now. I think there is also a political consensus, independent of whichever party is ruling at the center or even in the states, that after 1991 crisis, the consensus was to assign priority to fiscal stability in budget management. And that again brought in new rules, the Fiscal Responsibility and Budget Management Act in 2003, which put limits on fiscal deficit. Again, they were not rigid limits, as we saw during COVID, they were relaxed again. So in a sense, it was a kind of flexible, but not so much flexible rule. Governments have to go by that. There are, of course, one can always say, accounting jugglery and all that, but they are possibly within limits. One of the things that often it is criticized is there are a lot of off-budget loans which government guarantees, and that is not accounted for in the government budget. But again, at least most of it now is coming out in the union government budget. Last 4-5 years, it is explicitly. There are still, few things which possibly even the government may not know that they have given a guarantee like that 8 or 10 years ago. Obviously, the legal framework needs to be strengthened to make it transparent and accountable, and particularly at the state level. The FRBM Act, they also apply to state governments in the federal system. But again, depending on time, depending on years, some states are going through their legislature and relaxing it. But again, overall, I think I'll say that broadly, states are also concerned about putting limits on their deficits, at least the major ones. I think I had a PowerPoint, I didn't. Okay, it doesn't matter, I had given it in, but anyway, now I have spoken most about, I will not go more into Indian situation. Couple of things. Can I use it here, the pen drive? Pen drive, can I use it here?
Can we have some technical assistance here for Dr. Panda?
Okay, yeah. There is one file.
Right.
Now, some issues in the international context, since the topic was broadly around that. So, obviously, the need for preparing reliable, useful record of sovereign debt at the international level is a need, and without that, possibly international laws also might find it difficult to operate. What Chairman again was telling. But what should it cover? As I was thinking about it, I thought, what would it cover? For example, is it only union and state government debts? Or in a federal setup, only their union government? And possibly government guaranteed loans, say to the public sector enterprises. What about private loans guaranteed by the government? Then there are very innovative loan arrangements these days. For example, the resource-backed loan that is happening in some of the countries. Government may take it for, even advanced countries might like to take it for critical raw materials from a place like, for example, Ukraine. But there are also other examples. For example, between Chad and Angola, they entered into an agreement that Chad will supply cattle over 10 years period for repayment of 100 million of loan to Angola. They agreed on it. Now, how do we value this transaction over 10 years? If it is current transaction, we can value it at possibly current market prices. So, these are the kind of questions that will come up. I'm just flagging one or two issues. Similarly, commercial concessions as part of loan repayment. Again, valuation of that as we go ahead in preparing the registry. These are possibly some questions that has to be addressed. Then if a debtor is not able to pay in the agreed upon currency, say US dollar, due to geopolitical problems, as some of the countries are facing problems. Then again, how do we, an agreed upon currency again has to be there to even to convert it to some international comparable currency. Which one? I'm only raising questions because since I'm not from this field, I'll not go into details. The other question that at least some of the people from my field, economics, they are raising is, if we have one agreed upon development goal by the UN, like the social development goal, if you have to finance that, because that is agreed upon, signed by almost all the countries, If you have to finance that, how do we have an contractual arrangement for that? Can it be somewhat relaxed? Who will supply such large amounts? Can it be like the one that happened for financing the redevelopment of Europe after the war? I think these are coming up. Then there is another problem which I would like to just again point out. For example, the hedge funds are very active in purchasing debt at a discount, and then they pursue for full repayment. So can the borrower be a party to it? Otherwise, the debt burden, why the borrower was not able to pay to the original creditor, was precisely because of certain inability, certain disabilities on their part. Now, if the hedge funds ask for full payment, the same thing will continue. Then again, there might be default-like situation. How do we avoid it? If we make the borrower also a party to it, at the same time allow some reasonable returns to the hedge funds because of their risk, that possibly could be one way, but one has to again, details have to be seen by the experts. But at the end, I will just raise one question, that who will govern international settlement? These are sovereign governments, or at least to a large extent they are sovereign on their own. If they don't agree to some international arrangement, what will be the mechanism for governing, for enforcing it? I think that's one point on which legal profession must come out and say this body must have power, at least in some spheres, to enforce the mechanism countries have agreed upon. Thank you very much.
Thank you, Dr. Panda, for sharing your views on the debt crisis faced by India in 1991, steps taken, also the enforceability of international dispute redressal mechanism. Now I request Dr. Mohammad Hasnain, member of the Egypt Bar, to share his views on the topic.
Good morning. Thank you for giving me this opportunity to be part of this magnificent participation and magnificent conference. Today is a very urgent topic, especially in the South countries. Let me start first by saying that why states and governments go for debt. They go for debt because they would like to invest in infrastructure, they would like to invest in health, education, defense, and security. And because of scarcity of resources, they go for debt. And when governments and states decide to go for debt, they cannot resist the temptation of an open credit card. And once you use your credit card, you think that it's an easy money. You still lend, you still borrow, then you get stuck in the debt crisis. Once you get stuck in the debt crisis, you are under colonialization, which means that you are under the guardianship of your lenders. They tell you what to spend, when to spend, where to spend. This is the guardianship. But let me focus more on the relationship between the sovereign debts and human rights, which is the core of rule of law. Let me start by giving you the example of the European debt crisis, the Greek crisis. When Greece went into a debt crisis, it became under the guardianship of the Troika group, who controlled the country. Then everything has been under this control. Even court orders have been sidelined. Nothing is applicable other than the Troika's decisions and directions, because Greece has become inefficient in managing their debts. So they had to obey, they had to follow the directions of their creditors. In this example, the government has violated lots of constitutional things. Also, many courts' decisions have been sidelined, like when workers go for the courts to call for pensions, to call for decreasing taxes or whatsoever, these courts' decisions have been sidelined. So where is the independence of the courts? One more thing is the Argentinian debt crisis. When Argentina got stuck with debts, then their bonds treaties were under the New York law. Then Argentina's sovereign debt was controlled by a court in New York that says what to pay and how to pay these things. Can you imagine that a sovereign state's debt is governed by a court in New York? This was one of the reasons why there had been many resolutions by the United Nations to solve the issue of sovereign debts. One more example is the example of Jamaica, the example of Zimbabwe, the example of Lebanon, the example of Syria. So those are really examples. So when you go to stuck in the debt, this means that your creditor will tell you, please, could you increase taxes and fees because you have to pay. There are deadlines that you have to meet. You have to decrease your expenditures on health, on education. You have to increase the fees of resorting to courts. You have to increase the fees. You have also to control the courts when courts give decisions regarding to the rights of the workers or compensations against the government. You have to give them directions not to make so as not to make the budget collapse. So what does rule of law means in this issue? The last thing that I would like to focus on, because I intended to be short and concise as much as I can. Here in the state of Gandhi has adopted the policy of non-cooperation. But I tell you that there have been some suggestions when countries or governments got stuck in debts that you have to oppose these governments and you have to start this kind of opposition against them. But this does not solve the issue, because even if the government has collapsed or has left, the state or the people are still stuck with the debt, because you cannot leave that debt. You have to leave it. You have to pay it. Otherwise, you will not be paid again by your creditors. Moody's will reclassify you and degrade your standard. So you have to pay it. So better than opposition or non-cooperation with the government, we have to assist them by guiding them as lawyers and tell them what are the results of getting stuck in this kind of debt crisis, because it will not affect only the government. It will also affect the population. Thank you for your time, and thank you for your listening to me.
Thank you, Dr. Mohammad Hussain. I particularly found your illustration of the spending spree on the credit card, comparing it with the debt crisis, very interesting. Thank you. I now request Mr. Stephen Thiru, President of the Commonwealth Lawyers Association, to address us.
Thank you, Mr. Chairman, distinguished panel members. Good morning, ladies and gentlemen. In the time given to me, I wish to first speak about the Commonwealth Lawyers Association as an organization that represents 56 of the Commonwealth jurisdictions and countries. We carry a very strong rule of law mandate throughout the Commonwealth countries. And what is known as the sovereign debt crisis, or really the sovereign debt default crisis, is a rule of law issue. Undoubtedly so. And why is it a rule of law issue? Because one of the things that the rule of law prohibits is arbitrariness. And what we have in terms of sovereign debt and the treatment of sovereign debt defaults requires a coherent international framework founded on international law to prevent this arbitrariness. Now, this coherent system is something that should be under the aegis of the United Nations and not under the control of any of the so-called borrowers. Why? because we heard this term being used just now by Mr. Chairman, that there are predatory lenders. What are predatory lenders? These are persons who have strong economic power, and because these borrowers have strong economic power, they can impose unfair terms on borrowers, and then they hold borrowers to ransom. Now that is really the general framework, the general concern of sovereign debt and the sovereign debt default crisis. It does take countries into severe problems, social and economic problems, and indeed even legal problems. It shakes the very fabric of society in most countries. But this morning, I wanted to speak to you about a slightly different aspect of the sovereign debt crisis or sovereign debt default. And it's got to do with the use of sovereign debts for an improper purpose. Now, we all know what sovereign debt is. It's where the sovereign borrows for the benefit of the country. It is intended largely for long-term economic development. Instead of borrowing locally, it borrows overseas. Funds come from overseas, and it is meant to assist the country. But what happens when sovereign debt is used for an improper purpose? It is a rule of law concern, because it's a violation when the sovereign debt is not used for proper purposes. It is an instrument for corruption and abuse of power. It has been described as a kleptocracy. What's a kleptocracy? Kleptocracy is where agents or officials of the state appropriate funds or assets belonging to the state for their own purposes. It's called a kleptocracy because it's done by the agents of the state. And what's the asset here? The asset here is the fund, is the borrowing. What is borrowed by a country ostensibly for the use of the country is then becomes an instrument of abuse in the hands of the officials of the government, and mostly the officials. Now, one of the greatest kleptocracy in recent times is one that happened in my country. It's called the 1MDB saga or fund. What was intended, and again, the intentions were altruistic. It was intended that those funds were to be used for the long-term economic benefit of Malaysia. On paper, nothing wrong with it. But what happened was, through a series of opaque transactions and layered borrowings, spanning not one jurisdiction but many jurisdictions. I do not have time to get into all those jurisdictions, but you will read about prosecutions in Switzerland, indeed prosecutions in Malaysia, in Singapore, and so on, spanning all this jurisdiction, and importantly here, with a complicity of international bankers. Some of the well-known banks in the world were complicit in this. We had the largest, possibly largest scale embezzlement of funds, mismanagement of the funds. The funds were used for personal purposes of state officials, in this case the former Prime Minister of Malaysia, and as political patronage. Now, sovereign debt, to be very clear, is not meant for that. It is not meant for personal use. It is not meant for political patronage. How could this have happened? How could the international community have missed this? It is something that started in 2012, and when the news actually broke, it was sometime in 2016 when it broke internationally. When it was simmering locally, the government of the day put in place oppressive laws so that this will not come into to play. Yesterday we heard about Pota. Pota was used in Malaysia. We have the Sedition Act in Malaysia. The Sedition Act was used for those people who spoke about this. We have a law called SOSMA, which allowed for detention without trial. That was used, and a whole host of penal code provisions were used against anybody and everybody who sought to speak about this crisis that was looming in the horizon. Now, the effects of it is the same effect that you speak about a default. Generations of Malaysians are today lumbered with this act of corruption. we face the same downfall that you have when when states cannot meet their obligations under the fund. The break came in 2016 when despite all the issues that were raised locally, despite all the concerns that were raised locally and which were all just stamped, the break came in 2016 when the Department of Justice, US Department of Justice, and they have this initiative which is called the Kleptocracy Asset Recovery Initiative. All right? So you see, it's something at the international level. It's beyond the country. It is not within the control of any of the borrowers or lenders certainly. It is taken out. They came out with an expose where they were able to show how these funds were misused. They were able to trace how the beginnings of the fund, how the funds were moved from jurisdictions to jurisdictions, how banks were complicit, where the monies went, and short of naming the culprit who they call MO1, all right, which is Malaysian Official 1, and it didn't take a genius to figure out who is Malaysian Official 1, given all that had come out, they fingered and pointed to who was responsible for this. That happened in 2016, and despite that, we had no change of government until 2018. But in 2018, when there's a change of government, the former Prime Minister was prosecuted, and certainly others were prosecuted. And one of the spin-offs of those cases, he was convicted, 12 years imprisonment, and then he was pardoned. He's gone down to 6 years now or so. He's facing another prosecution for 1MDB. Malaysia has put together domestic laws that will curb, curtail, and have oversight over public financing. But having said all of that, and in this very short time, I just wanted to highlight to you that until and unless we have a coherent international law system that looks at first how sovereign debt is acquired, secondly, how sovereign debt is used, thirdly, how sovereign debt default is managed, the 1MDB saga will not be a one-off. So long as these loopholes exist, it will recur. The avarice of man is such, the greed of man is such, that this is an opening. Mind you, if 1MDB was repeated in any of our local jurisdictions, in other words, the funds were not sovereign funds, they were local funds. Do you know in most of our jurisdictions there's enough oversight, enough curtailment to prevent something like this happening? They would have been caught. Whether you take your insolvency laws, you take your bankruptcy laws, you take all the borrowing statutes that you have in your countries, they have enough mechanisms to at least put a check on this. But it's a free-for-all out there in the international arena. It's a free-for-all. So on the one hand, where we are looking for some sort of accountability as to how sovereign debt is managed, and so that generations of the members of the public in that particular country do not suffer. On the other hand, let us never assume that it cannot be abused. I'm here to tell you, the 1MDB experience tells us that it can be abused. It can be misused in the hands of the powerful. And those who end up, as it said, carrying the can, is you and I, members of the public. Thank you very much.
Thank you, Mr. Stephen Thiru, for this completely different perspective, how sovereign funds can be misused by the powerful. We've already encroached on the timing of the next session, so we can't have a question-answer session, but I'm sure the unique perspectives given by all the panelists will trigger thoughts and raise many questions about which we can have a discussion at a later point in time. Thank you for this.
We'll be starting our next session after the photograph. May I request Justice Aniruddha Mai and Mr. Yakesh Anand, Mr. Chandyok, Mr. Chami. Photographs हो गए? हाँ, sorry. I said photograph. We are leaving, Amarjit. Sorry. It's like a waiting seat. No, we are running. No, I can't. It's running short on time, so trying to manage whatever. Thank you all of you. Mr. Bruno Barata and Professor Dr. Prasad Mishra.
A very good morning to all of you. I welcome you to this working session on the capacity building in the legal profession of Global South for commercial disputes resolution. Today this is a topic which we all will be involved in directly. With the changing economic scenario all over the world, the legal profession has its own role to play. The capacity building in the legal profession is very important for the Global South. Latin America, Africa, South Asia and Southeast Asian countries are now contributing in a big way to the global economy. We have a big role to play in our legal capacity building. International arbitrations are taking place. The success of any economy depends on the commercial disputes resolution in its fastest way, in a transparent way and in an effective way. We as legal practitioners need to contribute to that. With the growing economy from the Global South, arbitrations are going in the established places in 3-4 jurisdictions only. And we find that the legal practitioners from these global south countries are very less in number, and also in many places almost non-represented. So today in this working session we will be hearing about various suggestions which are required for legal capacity building in our global south. As they say, the institutions, strong institutions build and thrive the economy, and it's not only the natural resources. So it is very important that the legal profession as an institution build its capacity to react to these changes, economic changes. Africa alone contributes to about $2.9 trillion to the international GDP. Global South countries are now increasing their contributions. Therefore, the need for commercial disputes resolution arises. The faster the resolution, the better for the economy, the better for the country. The transparency in such resolutions is also more important, the faith, so that the commercial ties increase, the economy increases, the prosperity increases. So it has a direct link with the country's prosperity. Arbitrations nowadays are the mainstay for the commercial litigation. Around 173 countries have signed to the New York Convention, which is about enforcing of our international arbitral awards. The arbitrations which take place in the global south also need to have cross-border implementation. That is equally important for the resolution of the disputes, the faith in the business, and the faith in the country's economy, and thus it will also attract investment and lead to a prosperous state. In this background today, we will be having with us renowned speakers from Brazil, one of the Latin American countries, from Russia, from Nepal, and of course from our very own India. I now hand over the mic to Mr. Yakesh Anand for introducing our speakers.
Good morning, everyone. The topic of interest today is very important. The Voice of Global South Summit is an extension of India's philosophy of Vasundhara Kutumbam, meaning one earth, one family, and one future. We have a panel of few speakers, and I'll introduce Mr. Amarjit Singh Chandiok, who's the dawn of the Indian bar. He's been practicing law for over 55 years. Yes. President in Seoul, India, member of Russian Center for Dispute Resolution, President of Madhyam, International Council for Conflict Resolution, former Principal Consul, European Union. He has been accredited as a member of Singapore International Mediation Institute. He was invited as an expert on Indian laws by various countries, tribunals of United States, United Kingdom, and Australia. Mr. Chandiok is a senior counsel in insolvency matters, arbitration, and mediation. He is an expert in commercial company insolvency laws. He is an established name in insolvency and bankruptcy laws. Is one of the senior most practitioners in these areas and a sought after expert. Now I request Mr. Chandiok to give his presentation.
That's why I asked Mr. Yakesh Anand this join the real word that you do. Otherwise my friends on the dais and off the dais will probably feel there's something else. I'm not a lawyer, but there's something else attached to it. So better be careful when we use our words. The topic is the need of the hour, according to me. we have seen the development of international law. It goes right back to WTO. Circumstances have changed. India has done its bit. If we look back to the history of this country, we find we were up with WTO disputes and complainant and respondent in, I think, the maximum matters in 79-80. A situation came when WTO became irrelevant. A stage that came also. But today, there is a fact that we have to all accept, and that is that India is an economic power. What we need to do is the discussion that we need to look at. How do we make capacity building? And that too in legal practitioners, or legal profession, of Global South for commercial dispute resolution. In fact, after long delay, we brought Commercial Courts Act in 2015. Fortunately, we amended it, and now things are more or less in place. But our experience in the last 2 years in the international front has not been very happy, whether it was treaty arbitration or whether it was commercial arbitration. We were not successful, despite the fact that India had foolproof cases. The reason is this, that's one of the reasons that we need to build capacity all over, not only in India. I fortunately have with my co-panelists from Brazil. I remember when I went there, when the BRICS Legal Forum was doing it, and we thought BRICS countries must at least develop a law first, where we exchange our young lawyers. We need to look at each other and then point out back into our countries what are the loopholes in our law. We must develop norms by which at least the BRICS countries' judgments passed or awards given are directly executable. I'm not making any adverse situation, but I know of a fact that an award made in India, when it came for execution against a Chinese company, they said we have no assets in this country. And when we went back to China to do it, they said we need to start the process once again. Now, if this is the situation across us, we need to amend ourselves. We need to bring those laws. We need to exchange our people as to what we should do. Singapore Convention was one thing that we thought we will be able to achieve by at least going to mediation, which mediation under the Singapore Convention becomes akin to a decree. But we have not been able to ratify that so far. Many of us have not been able to do it. Now, there could be some political reasons for it, there could be some other reasons for it. But what a lawyer has to play a role is the question that we are debating upon. I think let me start from my law schools. My experience shows some of the law schools, Amity, OP Jindal, have a special subject called international law for a child to pick it up and learn it. That's the beginning, which we have done. I'm sure other universities and law colleges will adopt it also. And they will also go into the same direction in giving them an expertise of what international law is, especially in commercial disputes. While speaking somewhere on Commercial Courts Act, somebody had put a question to me from the audience to say, what the India is achieving by making Section 12A added to the Commercial Courts Act? And I said, till parties take a stand in court, a mediation has become a compulsory there. So that people who are not even talking to each other after a dispute arose in commercial matters, they will maybe sit across the table with the mediator. And many times it has happened that you've seen miracles happening there. Because both sides are commercial. They are not looking at long-drawn battle in arbitration or even in the court. So when the mediator has a caucus session, you'll know what exactly the underlying interest of a particular party is. And that was the purpose why 12A was added. We need to also look at a need that we must provide, especially with respect to Global South. If any disputes arises between the countries, should we not first sit down to mediate? It may save us time, it may save costs, it may save many things. But the legal profession of the Global South will have to rise to the occasion to understand the principles of mediation, not otherwise. International disputes, cross-border disputes, the mediation principles are slightly different than what we do in domestic matters. And I'm sure those of you who are my foreign delegates here, I wish to bring to your notice that we brought an amendment into our Civil Procedure Code. And actually speaking, mediation picked up. Mediation is a very old situation in India. If anyone goes to Allahabad, you'll see in the museum a mediation settlement signed and written by Tulsidas Ji himself in his own hand. So mediation was not something new to us, but probably when British came, we gave it a go-by and we brought it back when we amended the Code of Civil Procedure. Ever since from 2006, if you see the journey of mediation, commercial disputes, to the last statistics I have been resolved over 53%. So 53% have not gone to court. They have not spent their time there. And instead, they have come back as partners as they were doing earlier and have gone through. Because ultimately, when you resolve a commercial dispute, it's actually affecting the economy of the respective country. So the bar has to rise to the occasion, and somebody asked me yesterday, so when is the next episode of arbitration? Bar Association has a wing of Madhyam which looks at mediation and arbitration. We had a founder, Sadhana Ramachandra, in her name, we had lost her, and we started doing episodes every 2-3 months, where we are looking at how international arbitration or arbitrations, disputes that are arising in interpretation of the arbitration can be solved to the youngsters. So capacity building is the need of the hour. And I'm only requesting to all my delegates that here, we must press our countries to come to a conclusion. New York Convention was made long ago. There are 174 countries to it. But can you see that? Read the provisions of Arbitration Act 1996. I have to still go to court to ask that whether my award should be implemented or not. Why should it not be automatic? Unless there is something else to it. If a decree of a court can be executed, then so should be an international arbitration agreement, award. But no, we still need that after 45, 46, 47, we go again those principles which are almost akin to Section 34 have to be done. And I think this forum would also note that we need to amend that too. Unless we find something so grave, so patently illegal, that you will not be able to recognize it. Therefore, there is a need for the bar to get up. Bar's capacity is important. And I think they well said, catch them young, and young would be from the law schools. And that's why I feel what MIT and what probably OP Jindal and 1 or 2 more schools, law schools are doing, we need to do that. The second question comes that with all humility at my command, I feel law schools have mushrooming in the country. Many of them, without naming it, Mr. Yakesh Anand, I'm just taking his name, called me up to say, I have given a consent, so the convocation, you will go there. I said, all right. I just went to Hyderabad to do a matter, and matter got adjourned. And my cousin was not well, so I wanted to see her. And while I was going, I saw that big board of that university, which only had 4 rooms, the rest was everything in tents. And I called Mr. Yakesh from there. You think convocation at such a law school or a university would you wish to come? So I need to make infrastructure changes. I need to make the students comfortable. And there's a need for us that student from one university of India goes to another university across the global south and learn. This itself will make a difference in our learning process. This itself will combine us to do something together to meet the challenges today. And with the economies going on, cross-border disputes are manifold. In fact, I find disputes are today arising when you are actually entering into a joint venture or some clause or something else. That also needs to be addressed. Only it is possible to do so if we are able to get to know everything that we are doing. Our lawyers must accept the fact that learning never stops. I think I'm taught every day when I'm briefed. I learn every day from them. Learning should never stop. And if that's the motto, then we'll never be able to stop to learn how to, with the changing economy of the world, how do we change these situations? A question arose the other day. The Honorable Judge, I was sitting in the court. The Honorable Judge said, what is your prima facie view? I said, the prima facie view has to be that by an order of the court, this international situation has changed. Therefore, jurisdictions have changed. Consequently, everything will have to be now looked at from a domestic point of view. Please see, an arbitration hub is today or in Singapore, London, Paris. Why are we in global south not creating our own hubs? Why are we going and rushing there? I remember long time ago, maybe I was early in my profession, I had asked the government, PSU, that why are you saying this? Why see your arbitration? And you say it's interesting to see it was an English company doing petroleum extraction in the Indian Ocean. And the agreement said it will be governed by Indian law. The arbitration said it will be governed by English Arbitration Act. Place shall be Malaysia. So people started running between London and Malaysia, which will have the jurisdiction. So we need to look at, because if we are conversant with the fact that what should we put in our agreements is also important, especially when they are cross-border. How do we express explicitly what is the intent of the parties and see how do we not raise questions in the arbitration agreement itself. How it can be done when the bar will have to start, each bar will have to do that, whether it's an Indian bar or everywhere in global south, to start learning the international norms now today. We just saw in the last session, sovereign debt. We in India, in the insolvency, has brought it down. But the Supreme Court said go up. So we're again back to square one. These are issues that we need to debate, and there can't be a better forum than what Bar Association of India has done today. All that we learn from these sessions should actually be put to practice. We all must go back, tell our respective authorities, law schools, bar associations, to please look at this and adopt something. With the economy going everywhere, and please look at this now. We started investment into this country. How will the investment be done if the investment we said, I will give you an option to go out of the shareholder, provided at that option I charge you interest at rate of 18%. this was not totally illegal, because we can't determine the value of a share after 10 years. Therefore, it is necessary that these fundamental norms that we need to adopt in capacity building must be done. And especially in its two-tier cities of India, there is hardly anything with respect to international law, international arbitration or otherwise. Therefore, we need to look at how we start to build the capacity, not only in the law schools, but also to our young lawyers. We explain to them and tell them. And not only that, we refresh ourselves. What are the norms? As I said, from WTO, where we have come today. Therefore, today, all this global south needs to make at least 3 resolutions. Number 1, that arbitrations, cross-border disputes shall be recognized and shall be executable straight away. 2, unless that award is contrary to the local law of that country, execution will take place. And 3, that the courts will also lend their support to ensure that awards are not remain on paper. I can only give you an example of blending between bench and bar. A clear example is Delhi High Court. Bar and bench have, if I can use that expression loosely, have actually colluded with each other. And see the infrastructure that we created. We have arbitration center, where there is time has to be taken. I have to block my dates to get a space there to do arbitration. I have a mediation center where I have 80 cases a day with 250 mediators, many of them who are doing pro bono. Now, these are situations that are happening, and these structures have come up only because the bar and the bench thought we need to look at together. So taking this only an example to say internationally, especially Global South, we all need to cooperate with each other. We all need to make something together, norms together, maybe fundamental, and see how do we enforce them in the next coming times. Times are changing. In fact, I see economics changing so fast every day that probably there's a need to make our amendments to law very early. Even the only law probably I've seen so much of amendment is insolvency. I had never seen a code being amended so many times by the legislature. And apart from that, of course, the regulator is doing so. But arbitration has been amended 2-3 times after 2015. But we need to look at arbitration, especially in the cross-border. We need to look at those Chapter 2 of our Arbitration Act to see how do we amend it to bring those norms into that. Time, I know, is running short. We are already late. I do not stand between me and my all other friends. I have many other things to say. And when there are the jurisdictions, we learn from them too and have a great day. Thank you.
Thank you, Mr. Chandiok, for the enlightening speech. While treaties and case laws provide the normative backbone for the international arbitration, it is the institutional collaboration and professional exchange that generates trust, networks, and skills necessary to sustain capacity building. In the recent years, a remarkable trend has emerged. The Global South is no longer a passive recipient of arbitration norms, but an active participant in shaping them through the cross-border partnerships. Law schools and universities, as emphasized by Mr. Chandiok, are also at the forefront of the capacity building. Now I invite Mr. Yakesh Anand to invite our next speaker on this topic.
Friends, our next speaker is Ms. Chami Yu. She is from Russia. She is an international expert, specialist, and with in-depth experience in collaboration and administrative work in an NGO for Russian lawyers. For over 6 years, built effective cooperation and bridges with Russian NGOs with 35,000 members and legal communities from more than 20 countries, including ASEAN, BRICS, CIS, EU member states, host of BRICS Legal Forum in Russia, and speaker at international conferences. She has organized a large number of legal courses on Russian legal system for young lawyers. For 2 years represented Russian Federation in working group on active political participation of minority youth of the Steering Committee on Anti-Discrimination, Diversity and Inclusion, Council of Europe. She possesses strong organizational skills and an international background is her multilingual and multicultural way. I'll now invite Ms. Chami.
Your Honorable Mr. Justice, dear speakers and dear participants of the second New Delhi Convention on the Rule of Law, today I'm representing the Association of Lawyers of Russia and I'm speaking in the capacity of the Head of Department for International Development. And today I would like to share some ideas of how to build capacity in the Global South. I would share some outlines from the Russian experience in this situation, and we'll speak about ongoing activities within the BRICS countries which are aimed at enhancing the capacity in our countries. So recent events have actually made us look broader, made us see the world much larger than we used to. And in the recent 2 years, Russian universities actively participate in moot competitions across Asia, as all the competitions in Europe and the United States impose certain restrictions and showed a little bias towards teams from Russia. So this year, the team from the MGIMO University, which is Moscow State University of International Relations, my alma mater, took part in the Vis ISMUT 2025. It's a major international arbitration moot court competition held in Hong Kong. And the team advanced to the round of 32, which is a small but significant achievement for the university, and their participation was sponsored by Russian law firms. And earlier the team competed in 2 pre-moot events in Kota Kinabalu and Shanghai, achieving a second place at the Shanghai Vis pre-moot and receiving an honorable mention for the best individual speaker at the BICAM APAC pre-moot. So what we can do is to create moot competitions within the Global South. The BRICS model, launched by Higher School of Economics, for example, is dedicated to investment cooperation and simulates a diplomatic conference on adopting a new investment treaty. Participants there are tasked with drafting an international investment treaty for protection of investors. This shows that law firms and universities and other interested parties, they should continue to provide financial support to young lawyers to help them develop skills in international arbitration, and not only in legal writing, but also in oral matters to make them capable of defending the interests of the clients in courts, in arbitrations, and these young professionals will actually gain the experience and become the next generation of arbitrators and lawyers in the sphere of arbitration. Moot competitions already include the ASEAN Moot Competition. It was held in 2023 in Kuala Lumpur for the first time. It's for the ASEAN young lawyers, and the Vis ISMUT. And there's a strong need to create moot competitions for BRICS, for Africa, for Latin America, and it will be made to strengthen the legal capacities across the Global South. It's actually a complex initiative, but we think that it's worth implementing. And I know that in India there are some moot competitions, and we could broaden it and enlarge it to BRICS countries as well. Another key priority is encouraging young lawyers to work for national firms and for national law firms to develop their potential at home and to improve our own national jurisdictions. Many graduates, after obtaining law degree abroad, they would prefer working there rather than go and return back home to build their careers here and to develop the capacities in their national jurisdiction. Others who study abroad, they often return without a full understanding of domestic legal traditions or how to effectively navigate their own jurisdictions, how to make it a better legal place. To address this, the government, universities, law firms, they should launch programs which can attract students to remain in their home countries or to contribute to the training of highly qualified specialists in international arbitration. There are such universal documents as, for example, UNCITRAL arbitration rules which the majority of the global South countries have adopted in their national jurisdictions. There are also documents which can guide how to conduct in arbitrations. For example, the recently renewed IBA guidelines on conflicts of interest in international arbitration, and which is actually praised among the arbitration community around the world. And in the context of the global South, our countries are recommended to pay attention to concept documents such as those. But we need to apply it with our own national perspective, taking into account our legal traditions and practice our history of law. What I'm trying to say is time concept, high value of politeness in the Indian business culture, for example, especially respect towards the elders, professors in Vietnam, respect for the monarchy in Thailand, Muslim traditions in the UAE despite its internationality. These all make our countries unique and we need to maintain it by all means. Another thing I would like to mention is educational programs. So for now, Russian universities, they have set and renewed contacts with law faculties and universities from Brazil, from China, from India, Vietnam, and some law schools are considering opening branches in the UAE, in Malaysia, in Thailand, and the main subject of the negotiations when universities, Russian universities, meet with the foreign universities, they talk about launching joint programs, educational programs in the sphere of law. So in Russia, the universities, for example, law degree programs today cover Chinese, Indian, Vietnamese, UAE law, while research in the field of the Eastern law is highly encouraged. During my first year of studies at the MGIMO University, it was actually in 2011, we learned such topics as court and procedures in ancient Egypt, the Society of Ancient East, the laws of Manu, institutes of ancient Chinese law, including private law concepts that existed back then, and Muslim law and others. And we think that all the universities in the global South, they should expand their disciplines covering legal traditions in the BRICS Plus countries, the history of the state and law in such countries, arbitration practices, and other aspects that are developed in such countries or are developing right now in these countries. At the International Law School of the Moscow State University of International Relations, for example, Chinese and Arab are taught as foreign languages, and the plans is to teach Vietnamese language as well. Considering Hindi, but considering that in the Indian business community, the English language is often more preferable. So right now in Hindi is just considering to be one of the languages at the International Law School. Also, an increasing number of Chinese, African, Vietnamese students are studying right now at the Moscow State Law University. The government supports such exchanges by granting scholarships to study in Russia. However, not so many foreign students are ready to study law in Russia because the legal itself, the legal language, and the Russian language, especially the legal language, is very complex. It's tough to learn. So, but I've recently worked with an intern. He's a student of the Moscow State Law University. He's from the Republic of Guinea. And his Russian was actually is quite impressive. So actually, everything is possible, and this is a proof that such challenges can indeed be overcome. And it just depends on how hard the student is ready to work on his language, on his skills, and others. Also, the BRICS Legal Talent Program that we organized in 2018, it is a program where BRICS students and young lawyers, practicing lawyers, they come together, they meet in a BRICS country, and they learn about the national jurisdiction, national legal system, all the aspects, and they are going to travel and meet with universities and law firms in these countries. And we think that it is kind of an initiative that needs to be continued, and we need to work on this further. Also, we can work on increasing the internships in arbitration centers in the developing countries. For example, in Malaysia, AIC, in Indonesia, BANI, in Vietnam, VIC, in Russia and other countries, in India. So we could learn about each other, learn about the arbitration systems of each other, not for only us, but for young lawyers. They need to immerse in this culture, immerse in these legal systems to understand how to work with the lawyers from these countries and how to work with the legal systems in these countries. And to sum it up, I would like to just highlight some recommendations and some conclusions. Firstly, we should strengthen academic and professional exchange between countries that share common legal values and approaches. For example, Russia, Vietnam, Russia, China, Brazil, South Africa, UAE, Egypt, and others. This is just examples. And we have discussed a lot of ideas during the BRICS Legal Forum, including legal education, including arbitration, and this was at the conferences in China, in Brazil, in South Africa, in India. But this is time to make it into the reality, to get into real steps. And this is our appeal to law faculties and universities and law firms to support and implement the ideas that I mentioned today and which we discussed during the legal forums in BRICS countries. Also, it is very important to build our national capacities. It is now the national priority of China, of India, of Brazil and other countries, and you can see it from the news. And I know that this conference is very presented by bar associations and lawyers associations, and we as professional organizations of lawyers, we shall push these initiatives and work towards strengthening the role of the legal profession, that the legal profession should be respected in our countries, among our people, and this remains one of the core missions actually at our Association of Lawyers of Russia. And for young lawyers, I personally think that the appeal is, which are the core for specialists pursuing a legal career. The first thing is awareness. Second is motivation and also fairness, but with a firmness to defend the interests of your client, of your country, of the organization that you work in. And for those who want to be international specialists, you need to have an open mind and languages. Of course, you can understand just the writing language when you work as a lawyer, but if you know the traditions, if you know the history, if you speak this language, people would respect you more, and you will become a trusted partner, a partner who can guide your colleagues, and this would facilitate your work and your career a lot, believe me. And finally, I would like to express my thanks to the organizing committee, to the Bar Association of India, to the participants for organizing and making this event such a wonderful place. And thank you for your attention and time.
Thank you, Ms. Chami Wu, for your views. In fact, endorsing your views, I would like to say that the professional associations should also provide mentorship which is often the most direct form of capacity building. Further, there should be a program for pairing the young lawyers with senior arbitrators. And there should be providing of free workshop by these international arbitration centers in various global south countries, providing free workshops and networking opportunities for young lawyers so that they are exposed to international arbitration. Because this will translate into tangible opportunities for these young lawyers and who will be exposed to such international standards. With this now I ask Mr. Anand to invite our next speaker.
Thank you, sir. Our next speaker is Mr. Bruno Barata from Brazil. Bruno is the founding partner and head of the international desk at BCDM law firm. He is a specialist in leadership at Harvard Law School, LLM from FGV, member of the National Commission for Sustainable Development Goals of the Brazilian federal government, Secretary General of International Relations at Brazilian Bar Association. He is a board member at Alps Academy, Switzerland, member of the Anti-Corruption Task Force at the United Nations Global Compact, board member at Exam Compliance Guide, Secretary General of BRIC Legal Forum, member of the Executive Committee of Legal G20. Now I ask Mr. Bruno to give his presentation, please.
Thank you so much. Good morning, namaskar, dear panel colleagues, distinguished guests, ladies and gentlemen. It is a profound honor to be here in New Delhi to speak at the second New Delhi International Rule of Law Convention, and I'd like to congratulate the Bar Association of India, a very dear partner of the Brazilian Bar Association. For who doesn't know, the Brazilian Bar Association is the world's largest legal association with 1.4 million lawyers, 1.4 million members. So we have a very huge organization and with a very huge responsibility as well. So I'd like to congratulate the Bar Association of India in the person of its president, my good friend Prashant Kumar, for the wonderful arrangements for this event. It is also very good to see a lot of familiar faces and to see again my good friends from India, a country with a vibrant economic landscape and a sophisticated legal tradition, making it the perfect forum for this crucial discussion on capacity building in the legal profession of the Global South for commercial dispute resolution. I have spent the last 2 decades almost practicing corporate law in Brazil. I have been advising clients from several jurisdictions, from India to United States, France, Germany, China, Argentina, and others, on how to navigate the turbulent waters of an emerging economy, often mediating the intersection of local realities and international capital. This experience has shown me that while the geography of global commerce has shifted dramatically southward, the geography of dispute resolution has been slower to adapt. Today, I want to discuss how we as legal professionals in the Global South, especially, can bridge the gap, not by isolating ourselves, but by building the expertise and institutional credibility required to manage the complex disputes arising in our dynamic markets. Let us begin by acknowledging the established centers of international arbitration. These jurisdictions have earned their reputations. They offer neutrality, deep expertise, high-quality institutions, and a history of stable, predictable jurisprudence. As a practitioner, I respect and utilize these centers frequently. They set a global standard. However, the world economy in 2025 is fundamentally different than it was 30 years ago. The rise of emerging economies is not just a trend, it is a structural reorganization. The economic synergies between regions like Latin America and Asia, or Africa and the Middle East, are creating vast new corridors of trade and investments. This new reality demands a new approach for dispute resolution. Our goal should not be to replace the established centers, but to create a multipolar world of dispute resolution. A network of centers in the Global South that offer equivalent excellence, but with the added advantage of proximity in the contextual understanding. Capacity building is the roadmap to achieving this vision. Why does the status quo persist? Why, for example, do contracts between, say, a Brazilian agribusiness firm and an Indian importer often end up being governed by English law with arbitration seated in London? for example. It is a rational choice based on perceived stability and neutrality, but this choice carries significant hidden costs. The financial and logistical burdens are immense. For large multinationals, this is a merely cost of doing business, but for the small and medium-sized enterprises that form the backbone of our emerging economy, the cost of a complex arbitration in Europe can be existential. When a dispute regarding an infrastructure project in Brazil is adjudicated by arbitrators, however brilliant, who have never navigated the Brazilian bureaucracy and understood the nuances of our content culture, something vital is lost. Decisions may be legally sound according to the black letter of the law, but particularly divorced from the commercial reality on the ground. The sheer volume of South-South economic synergies makes this deficit unsustainable. We need legal professionals and institutions that understand this context intuitively. We must transition from being mere importers of legal standards to developers of best practices tailored to the realities of emerging markets. How do we build this capacity, and more importantly, the trust that underpins it? The Brazilian experience offers some insights. 30 years ago, Brazil was viewed with a deep skepticism by the international community regarding dispute resolution. We were seen as protectionists and our judiciary as slow and unpredictable. The turning point was a concerted, systematic effort. It began with the legislative modernization, our 1996 Arbitration Act, based on the UNCITRAL model law. But laws are only as good as institutions that uphold them. The real catalyst was the evolution of our judiciary in Brazil. The Brazilian Superior Court of Justice, the STJ, adopted a decidedly pro-arbitration stance, consistently respecting party autonomy and efficiently enforcing foreign awards. Last but not least, in this topic, was Brazil being an early adopter of technology in the system of justice, meaning not only the judiciary, but also the legal profession, we lawyers and the law firms. Adopting virtual hearings since almost 10 years ago, virtual court sessions, generative artificial intelligence for legal documents and court decisions, predictive analytics, and a strong support of the adoption of alternative dispute resolutions, and also the online dispute resolutions, the ODR, including a mandatory mediation session before litigation case is initiated in the courts in Brazil. Brazil is also one of the world's largest hubs for legal techs, companies that provide technology solutions for the legal market and the judiciary. Furthermore, we recognize that complex commercial litigation requires specialized knowledge. We established commercial courts in major economic centers. These courts, with specialized judges, provide faster, more technically sophisticated decisions, increasing predictability for business. The key lesson is that building capacity is not just about training lawyers. It is about cultivating an entire legal ecosystem that international and domestic capital can trust. Looking forward, I propose 4 strategic pillars for capacity building across Global South. First, hyper-specialization. We cannot be just generalists. We must develop deep expertise in the section driving growth in emerging markets, commodities, complex infrastructure finance, energy transition, and fintech, for example. A lawyer who understands the intricacies of rare earth mineral extraction is more valuable than the one who only understands the abstract principles of contract law. The modern lawyer doesn't need to understand just law. It must understand the client's business. In the end of the day, we are all entrepreneurs, and our law firms are our companies. Second, institutional integrity and digitalization. We must continue to strain our regional arbitration centers, ensuring their governance rules and administration are impeccable. Trust is built on transparency and efficiency. Furthermore, we must aggressively adopt technology. Online dispute resolution that I said before, the ODR, is not just a tool for convenience. In the vast territories of the Global South, it is a vital mechanism for democratizing access to commercial justice, especially for small and medium-sized companies. Third, cultivating the cultural quotient. This is our unique competitive advantage. We must train our professionals to leverage their understanding of local cultures, negotiation styles, and socioeconomic context. recognizing the unspoken dynamics in a dispute is often the key to resolving it effectively. This nuanced understanding is something external jurisdictions often lack. And fourth, the cross-border collaboration. While we respect the tradition of the Global North, we must invest more in the South-South exchanges. We need lawyers who are comfortable navigating the similarities and differences between civil law systems in Latin America and common law systems here in India and other parts of Asia and Africa. In conclusion, building legal capacity in the Global South is not a matter of regional or national pride. It is a matter of economic necessity. As emerging markets take center stage, the ability to resolve disputes efficiently, fairly, and with a deep understanding of the local context becomes a strategic asset. We recognize the value and contribution of established centers in Europe and elsewhere. They will remain vital hubs in the global legal architecture, and the emerging economies will keep using the arbitration centers. But the time has come to offer credible alternatives by investing in hyper-specialization, institutional integrity, technology, and our cultural understanding. We can build a multipolar world of dispute resolution. This is not only serve our own economies, but to contribute to a more balanced, resilient, and equitable global economic system. Thank you very much.
Thank you, Mr. Bruno.
Our next speaker is Mr. Professor Vijay Prasad Mishra, President of Nepal Bar Association, now called upon to speak. We must thank him. He has brought a delegation of over 130 lawyers from Nepal to attend this conference. Big applause for him.
Thank you very much for this opportunity, all the panelists as well as participants. On this presentation, capacity building in the legal professions of the Global South for commercial dispute resolution, I am trying to highlight Nepali perspective. Basically, the present position of commercial disputes resolution in Nepal in the light of socio-economic and political landscape would be the matter of coverage. Then Nepalese legal practitioners' competencies and weaknesses in commercial dispute resolution, identifiable steps taken by Nepal Bar Council and Bar Association vis-a-vis capacity building in commercial dispute resolution, and finally I will try to shed light on the way forward. Nepalese First Company Act as a part of commercial law was promulgated in 1930s, before we got democracy. It was the law intending to boost up economy through companies, but no many more companies were established. Few industries under the control of the rulers came into being. They could not sustain for a long time. General law was country code that was made in 1854 after our ruler Janga Bahadur visited Europe. Country code 1854 was replaced in 1960s by new country code incorporating values developed in the world during the interval. In the course, Arbitration Act was made in 1981 when the country was having controlled economy, licensing system, establishment of the industries and business activities on the interest of the rulers. The economy was not liberalized. Following liberalization, globalization, adoption of privatization policy and law, we replaced Arbitration Act in 1999, which has been the existing law. Arbitration Act inter alia provides ex equo et bono, an amiable compositor. That is not practiced. Ex equo et bono, an amiable compositor provides wider opportunity to arbitrator to change the claim and to deliver award beyond claim, counterclaim, rejoinder and others. That is not practiced. And our experience is after arbitrator delivers award, there is system of filing petition in High Court. High Court delivers decision either by upholding or reversing or telling arbitrator to revisit award. After that, dissatisfied party enters into Supreme Court and it is taking long time. The question is, if everything is finally settled down by the court, what is relevance of arbitration? What is the basic norm of arbitration? How is it treated? That has been the question, fundamental question, over which every time we are discussing, representing different parties. Now, apart from this, commercial dispute resolution is also handled by Civil Code 2017, which is third generation law following 1854 Country Code, Foreign Investment and Technology Transfer Act 2019 is also in the course. We have ratified New York Convention on Enforcement of Foreign Arbitral Awards in 1998. Special commercial benches are established in High Court, not in District Court, not in Supreme Court, because we consider Supreme Court judges are specializing and getting adequate knowledge and experience in all the fields, including commercial. So there is no commercial bench. We are having at the present time the generation trained in general laws, basically guided by Country Code. At present, graduate courses are designed in line with international standard, incorporating all the recent developments of the countries. And that has eased, the scientific development has eased the access into global resources to our students and teachers, law practitioners, judges who all are associated in one or different form in commercial field. We also offer Master of Laws, LLM, after 1990s. Then, a specific sect of lawyers practice arbitration. It is seen as secluded area of law. We are developing arbitration practicing lawyers as well. In terms of their contribution, we are training them as well. There is lack of abundant Nepalese legal literature relating to commercial law. Practice of mediation is encouraged by courts, resulting in many commercial disputes being resolved in such a manner. So, arbitration, mediation, negotiation, conciliation, all are existed. But so far, result of mediation is concerned. Result of dissolution of the case by the court is ranging large, is giving more result than mediation. On the other hand, Nepal Bar Council has recently established Lawyers Academy, in which President of Nepal Bar Association is the head. It is represented by different sectors of legal organization. It has designed commercial law course and offering training in different parts of the country. It has categorized lawyers into Okay, lawyers in necessity of basic course, advanced course, 10 years, 25 years of practices have been designed. Publication is also there. In the publication, commercial law issue is also the case. In 2025, recently we have published Bar Council Journal with the incorporation of commercial law articles. Nepal Bar Association is also publishing, doing seminars, national convention once a year, once 3 years, participated in by more than 3,000 lawyers. Apart from this, there is Nepal Council of Arbitration, Nepal International ADR Center, NIAC, which provides set of rules and encourages alternative dispute resolution in commercial dispute. This is this scenario. We have challenged to make arbitration institutions robust, widespread in commercial disputes. We are focusing on the skill building as well as training. We are suggesting universities for the revision of the courses. Then we want to bring our practice into Asia Pacific level by exchanging information and others. For non-ADR as well, there is focus for special court, tribunal, traditional courts strengthening. In our context, there is informal agency active. Some of communities have their own legal system based on custom and tradition. Modern law is still today being unable to penetrate their tradition. So they settle down their dispute by appointing their one judge that is matching with arbitration practice. And we are also seeking permission of the court for the enforcement of the foreign arbitral award, but reciprocal agreements are not significantly made, so that this factor of law is facing crisis. In the meantime, by Lawyers Academy, we are training to the lawyers, utilizing our resources. And finally, before say thanks, I should say Nepal Bar Association at present is preparing to establish arbitration center with the cooperation of Nepal Engineers Association, Nepal Construction Entrepreneurs Association. We are exchanging memorandum of understanding among each other, and Bar Association is to look after purity of justice. Bar Association is to put judges in track. Not only this, it is also to play trade unionist role, look after members' welfare, expansion of the business. Since number of students is mushrooming, schools are also grown. What business can we give to them? What bread should we share with them? That is the challenge we are facing at the present time. And in this global village, in order to brighten each other's knowledge, we are to exchange materials, establish a center for exchange of the information, and more importantly, do this kind of seminar conferences, which may work as additional part of Lawyers Academy from time to time. Thank you very much for listening me.
Thank you, Dr. Mishra. With this, we come to the end of this working session. From the present discussion, one thing is underscored, that capacity building in the global south is not a luxury. It is a necessity for equitable participation in global commerce. For this potential to materialize, we must move from diagnosis to prescription. identifying sustainable strategies that will empower current and future generation of lawyers, judges and institutions. Because of paucity of time, we are not having any question answer session. Thank you.